Hey everybody, Jonathan here. Hope you guys are doing really well on this Wednesday evening. It's kind of chilly where I'm at, but I hope that everybody's staying warm if you're in a cool place. I have a guest today, an old friend of mine, Jeff Herman. Jeffrey Herman is an attorney in Arizona with a law firm called Desert Disability, and he's going to join me to answer questions and to really talk about some interesting developments going on with Social Security. Jeff, how are you doing tonight?
I'm doing excellent, Jonathan. Thanks for having me.
Absolutely, absolutely. And Jeff and I actually, it's one of these things in the now with everything being remote. Most, a lot of the folks that I know in the Social Security world are people that I've kind of met virtually, and we actually met in person. Was it this past year? Or you last? I can't remember when it was. It was the Nader convention in Atlanta.
Nader
Was it? I'm not sure if it was earlier this year. March, was it March? Okay, so we actually met in person, which is kind of unusual, but it was kind of nice to do that. So anyway, before we go into questions, one of the things that Jeff and I were talking about is some changes in the way Social Security is evaluating vocational evidence. And this is actually kind of a big deal. So I wanted just to kind of lead off by talking about that, and we'll talk about some of the implications of that. We will get to all the questions as we always do, but let's first kind of talk about this change in the vocational analysis that Social Security is using. Jeff, can you tell me just kind of big picture, tell everybody kind of what this change is and what you see it meaning?
Yeah, sure. Well, as we know, when it comes to disability claims, there's and hearings, there's a vocational expert who will testify. And for the longest time, Social Security has relied on central publication known as the Dictionary of Occupational Titles, DOT. This is a publication from the late 70s, the Department of Labor. It is known to be very outdated, and Social Security has just announced a new regulation that's going to come into effect after January 6th of this coming year.
Next year, right.
Where essentially vocational experts will be able to utilize other publications, not just the DOT, and testify more based on their experience regarding the ability to perform certain occupations as well as occupational statistics.
Yeah, and just so everybody knows, the DOT, this has kind of long been the bane of disability attorneys. It contains theoretically every job that exists in the economy. It was last updated in 1991, and some of the jobs in there were last updated in the 70s, and there are jobs in there that are just absolutely obsolete. They make no sense, but and Social Security over the years has told judges and vocational witnesses don't use certain jobs anymore. There was one for years that judges would use to deny claims called surveillance system monitor. And they basically now have decided that doesn't even exist anymore. But there's just all kind of microfiche things. And then, the example I always give was, a copy machine operator, where it used to be you go to a copy machine and put a piece of paper on and hit a button. Now, you scan it, you've got to be able to use a computer. It's a much more complicated job. So the point is that judges were using these outdated jobs and saying, well, you could do this job, when in fact it was a lot more difficult, either physically or in terms of education and training requirements than what happened in real life. But they were still using it to deny. The problem is that Social Security has tried for years to come up with an alternative, but they have not been able to do it. Now, let me ask you this, because it looks to me, I know in hearings I'm doing, judges will ask the vocational witness, what are you using to make these determinations? Anything other than the DOT? They still are talking about that. I use my experience. I use the Department of Labor, Bureau of Labor Statistics, and things like that. So they're sort of already doing that. But I think that they're going to rely more on experience. That's kind of why I'm reading that. They're going to rely more on their experience in job placement, things like that.
Well, what this rule is going to replace is the requirement for the judge or the adjudicator to resolve the conflict between the DOT and the vocational experts on experience testifying based off of that. Now, that's no longer going to really be the case. Vocational experts are really powered by this new regulation. And I do think it is a necessary change in moving away from what we know to be a more archaic Dictionary of Occupational Titles, but it's certainly going to make our job as representatives a bit more challenging.
what do you think the net effect is going to be in terms of approvals or, just in testimony? Any sense of that, or it's too early to tell?
I think it's a little early to tell, but we've talked numerous times in the past about difficult judges. We're going to be talking a lot more now about difficult vocational experts and difficult vocational specialists.
Yeah.
And so, being that now vocational experts can rely on multiple publications along with their own experience more, we're going to have to be a lot more prepared to anticipate more of a lengthier battle at cross-examination.
One thing, and we'll leave this topic, but, one thing I'm just curious if you've had the experience, one of the questions that judges always ask is, if a claimant would be off task meaning not focused on the job. And some judges use a 10% off task outside of normal breaks. Other judges use 15%. I've never understood why that's not standardized. Why is one judge at 10% being off task is too much? The other job, you could be 14% off task and that's still okay. But again, I don't know how they, if there's any sort of standard for something like that, but that, it seems to me is an inconsistency that I just see on a kind of a regular basis. I don't know if you see that in your cases as well.
Oh, yeah, sure. I would say the norm seems to be about 10% or greater off task. I've heard vocational experts testify that skilled occupations can get up to 20% off task even, which is outrageous.
Yep.
10 to 15% seems to be the norm.
Yeah, I still think, and we'll leave it at this, I still think that, if a judge wants to approve you, he or she will find a way to do it. If he doesn't want to approve you, they'll find a way not to approve you. I still think it's much more difficult if you're under 50 rather. If you're, between, 25 and 49, it's more difficult. Once you're over 50, it becomes a little bit easier. And again, I just think that judges are going to, they'll adapt. They know what the vocational witnesses are going to say. It's not like there's any surprise. This is just kind of going through the exercise. So anyway, is that your take as well?
Yeah, I do think judges are trained. This was covered at one of the conferences that I've been to, that ALJs are really trained to have a decision in mind even before they get to vocational testimony on the case. Oftentimes, even before the hearing even starts, judges already have an idea of which way they're leaning. But vocational expert testimony can be unpredictable.
Yep.
Part of this new regulation does state that the issues with vocational testimony should be cleared up during the hearing, not afterwards in a post-hearing memo, but in the moment. Examination. So we're certainly going to be a lot more prepared.
Yeah. Well, and I guess final word on this is that, it's all, generally speaking, changes in the Social Security decision-making process are not good for claimants. Generally speaking, the one exception to that was when they changed the look back from 15 years to 5 years. That's been helpful. But otherwise, it's just still going to be a challenge. And I think that, they're looking for ways not to approve people. And I think that's going to continue. Okay, let's go to some of the comments here. So some of them are just folks. Mary Lou says hello, Mary Lou. Wasn't that a song at some point? Hello, Mary Lou. Goodbye, heart. I think was the frame. I'm aging myself there. Okay, I think it was like the Everly Brothers, if I'm not mistaken. All right, G.I. Jose. Good evening. DDS is supposed to take 90 days. At times they go past that time frame, but if you've seen them make decisions quicker. I will tell you, Jose or Joe, I know you're Joe, the 90 days is aspirational. There is I don't know any DDS that's making decisions in 90 days. I think that they go past that time frame all the time. Do they make decisions quicker? Yeah, occasionally, but it's pretty rare. Your take, Jeff? you're not seeing 90 days.
We wish.
Yeah.
No, it's unfortunately that's just not what we're seeing here in Arizona either.
Nope, I would agree. All right, now here's another one. Joe says, and I think I know your answer to this. Is it worth filing an unfair treatment complaint against ALJ for ethics, lack of competence? My answer is going to be no. I think that's a real uphill battle. I just don't know that. First of all, accusing a judge of if a judge doesn't approve your case, that doesn't mean he or she is unethical or incompetent. Some judges, approve 20% of claims. Now, is there an argument that a judge who approves 2 or 3 standard deviations less than other judges, there's a problem there? Yeah, but I don't know that anybody's made that argument successfully to an appeals court, that a judge is inherently biased because of the low approval rates. Do you find that where in the cases, it just seems to me that, you get a judge, you go to any one hearing office, you may have a judge that approves 65 or 70%, the judge next door is approving 20%. Do you find that as well?
Oh, absolutely. That's, the range is pretty large. I think we have some judges in the Phoenix hearing office that approves as low as 13%.
Yep.
And seen judges that approve upwards of 80%.
Yeah, and that's
the luck of the draw. It does enter the equation for success, but
it really shouldn't be that way. That's kind of a lottery, and I just think that, look, I've had cases. I had one recently where I had I thought the case was good, but it was probably, on the marginal side of good. Let's put it that way. It was okay, but it wasn't like a slam dunk. Not that there's anything such as a slam dunk, but this judge was looking for a way to approve the case, which ultimately, he even said to me, he goes, it's going to take me a while to write this decision. I've got to come up with a good rationale to do it. And I appreciate that. And again, the person's deserving. But, when you see these judges that approve 30% of cases and they just, they ignore, any opinion evidence, and they ignore testimony, it's really, really frustrating, because you've waited 2 years and you get a judge who just doesn't believe in approving people. Like, why are you a judge? I understand the concept there. But yeah, I think it's maybe a power thing. I don't know. But I think that, unfair treatment, that's a pretty big bar to get over. Ethics, you got to have some really ironclad evidence. And again, there was the Eric Kahn case where there was evidence, of a judge, on the payroll. The attorney was paying the judge and paying doctors, but that's pretty rare. And unfortunately, that case created a lot of havoc in the system by eliminating the treating source rule and creating all kind of problems, even though that was the outlier, but it still created a lot of problems. But I think, Joe, that, pursuing a complaint against the judge is probably not going to go anywhere. You're free to do it, but I don't think it's going to go anywhere. Okay, so I see you don't stay up. Okay, I get you there. Okay. All right, so there's several here, so let's just go through it. Good evening, I'm Jessica, 42 years old. Hello, Jessica, with 3 previous back surgeries. First one at 17, severe stenosis, large herniated disc at L5-S1, nerve root compression, recommended spinal fusion. Well, you're terrified of that, understandably so. Failed chronic moderate radiculopathy in the left foot, foot deformity, mild foot drop with recurrent foot injuries, all due to previous back surgeries, recommended reconstructive surgery. Okay, so there's a lot of stuff, and instability. There's more and more and more, overactive bladder. We got panic attacks. Okay, all right. Somebody calls you with this type of situation, Jeff. How do you analyze it? I realize you're not going to see, without looking at the evidence, you can't say for certain, but just initial observations on something like this.
Sure, yeah. Well, looks like Jessica falls in that range of claimants under 50 seeking disability, which we know they have to prove an inability to work any job at all full time. What are the theories? We have less than sedentary. So basically, the record to show that there are such significant limitations sitting that you wouldn't be able to sit for 6 hours, maybe an 8-hour workday. And also developing other conditions to try to eliminate other work at the sedentary level. I look at hand limitations, any cognitive limitations. I think at that point, it's really about eliminating jobs as possible, utilizing other conditions, and hopefully get supportive medical opinions too.
Yeah, no, I would agree. I think that the big issue is the age. If she was 56, I think this case is obviously a lot stronger. In your 40s, it's more difficult. And I think that, the way Jeff is looking at it, and I would agree, is, you have to look at everything in disability through the lens of how this affects you in a work environment. And so, the way I explain to my clients is, imagine I said to you, here's a job, you're sitting in an air-conditioned warehouse, you can sit or stand, you're putting ink pens in a box. There's not a lot of interaction with anybody, minimal interaction with coworkers and supervisors, but the main thing is you got to be there 8 hours a day, 5 days a week.
Right.
So, the panic attacks, that's going to eliminate jobs where there's interaction with the public or coworkers, for example. A bladder issue, overactive bladder, that's a problem. And I see that's a significant issue because it's going to mean unscheduled restroom breaks. And that can be a significant issue. The fact that you've got these significant back issues, you've had surgeries before, they're recommending a serious back fusion. I think that, it's certainly reasonable to expect your level of pain to be debilitating with all those surgeries. So this is one of these cases in my mind where, even though you're under 50, the medical is probably going to be pretty strong. So this is going to really turn, in my opinion, on if you get a judge who is going to be reasonable about it, because some judges look at everybody under 50, and if you're not on your deathbed, they're going to turn you down. Other judges realize that a person who's 43 or 45 or 47 can have really, really serious problems. So, that's kind of what I would tell you. I mean, it's just, it really just, this is going to be to some degree the luck of the draw, because you just don't know which judge you're going to get. If you happen to get a reasonable judge and the medical evidence is really compelling, then I think you have a shot. I also think this is a situation where, if you've got this level of back impairment, it's certainly reasonable to expect a lot of pain and a lot of limitation in terms of activity. By the way, you don't have to have the surgery. Something people sometimes ask is, they've recommended surgery, I don't want it. You don't have to have it. There's no requirement you have it, but it does indicate something serious. So that's kind of the way I'm seeing it. It's a good case medically. The big issue is your age, I think is the way I'm seeing it. But the other things, like Jeff says, it's just, you just eliminate categories of jobs, and if you're, you just make a compelling argument that everything she's listed here is going to eliminate categories of jobs until the point where even a simple sit down sedentary job just would not be possible, and that's where you want to end up.
Yeah, I agree.
All right, Ms. Bell, can I get SSI, SSA should get approved for LTD? I'm currently fighting with the attorney. You recommended. He is great. Okay. I'm not sure who that is, but okay. So can I get so I think you're asking about long-term disability. My observation is long-term disability has different standards than Social Security. Most of the time they do require you to apply for Social Security because it reduces what they have to owe. So getting approved for one is not binding on the other. So I just think that, if you get approved for Social Security, that is certainly a factor. I'm sure long-term disability would take consideration, but, again, it's not binding on them. And, long-term disability many times will have a own occupation definition for the first year or two, where Social Security is everything. And then, long-term disability also typically will limit you to a year if it's mental health. So there's a lot of different things. Do you do any long-term disability? Do you see many of those cases?
Yeah, my firm started accepting long-term cases about 2 years ago. So about 5% of our client base. I agree. I mean, there's a lot of similarities between the two, but there's also differences. With long-term disability, there's so many different insurance carriers, really depending on the particular policy. I've seen a lot of plans that say, can you return to your work that you were last doing for the employer, or can you earn at least 80% of your indexed earnings? If so, then you're not qualified for long-term disability. So I'm not entirely understanding Mrs. Bell's question here.
Right. My sense is what she's asking is, if you get on Social Security, is that binding on long-term disability, or maybe vice versa? And I think, as we pointed out, could be very, very different standards. But yeah, I mean, I think that, one of the issues that sometimes pops up is, if you're getting long-term disability and you win your Social Security, it's not going to really, you're not going to see a difference. There's not going to be any more money coming your way because long-term gets to offset whatever Social Security pays you.
Right.
What it does, though, is it gives you backup, because if long-term disability starts playing games and they cut you off, you've got Social Security in the background. You've also get cost of living with Social Security. You get Medicare with Social Security. And plus it's required in the policy most of the time. So there's a lot of reasons to pursue it. But again, it's that's why the word disability, it can have a lot of different meanings. The VA has one meaning of it. The federal government on other programs has a different meaning. Social Security has one meaning. Long-term disability has a meaning. Private long-term disability, like if you buy your own policy, not through a company, can have a different meaning. It's a generic term, and you really have to look at the definition. And Social Security's definition is, the inability to do what they call substantial gainful activity, which is, can be defined with a dollar figure, $1,550 in 2024, $1,620 in 2025. Whereas long-term disability may say if you're working and you're earning $800 a month, they may reduce what you get. So it's all about the definition. Let me ask you, and this, this is an interesting time. Obviously, everybody's familiar with this crazy situation where this guy blew away the CEO of United Healthcare. Do you sense that insurance companies are going to be under I shouldn't say it under the gun, under more scrutiny in Congress or elsewhere because of some of the stories that are coming out about United Healthcare and the way they just deny people, and of course you see that in the long-term disability world. Do you think there's going to be any kind of congressional action, or is this going to be just something that's going to blow over? Any sense of that?
That's an interesting question.
Mm-hmm.
Certainly, insurance companies are in the spotlight right now, which they do not want to be in the spotlight, of course. We all know the underlying philosophy is to deny.
Yep.
I think I saw a headline pop up today on my feed about Amazon removing certain merchandise for sale that had the three word that the alleged shooter had written the bullet casings. But I think that Congress could certainly step in if an issue really does continue to grow here. But it is certainly not a good look for insurance companies.
No. I mean, I was just amazed. I mean, I don't look on social media that much, but I do, because I'm posting to it, and sometimes it's being posted automatically. But I mean, you look, and I was just shocked about how many people were taking position. This guy had it coming to him. Right. And, I don't feel sympathy for him at all, because he was responsible for turning down, and causing death and pain for a lot of people. I mean, that's a pretty cynical, I mean, I understand the sentiment, but, I mean, that's a pretty harsh look at it. But again, I've never been in a situation where a loved one, I had to watch a loved one, die or suffer because of insurance company shenanigans. And, I suspect if you have that in that situation, you'll be a lot less sympathetic to this gentleman who was gunned down. That's obviously not the way to solve problems in this country. But I think it certainly, my guess would be that it may result in congressional hearings. Now, again, we have a different Congress than we, in 2025 and in 24. But I think that the public may demand that some of these insurance companies answer. And I know that in some insurance settings, there are requirements that a certain percentage of premiums is paid out in claims. But I understand United Healthcare had this algorithm where they would just deny people, there was really, they would just ignore their own rules and just deny people, knowing that most people didn't have the resources to fight them. Mm-hmm. And, that's not a good thing. I mean, again, I think that, it's unfortunate that insurance companies do that. Now, my wife does, workers' comp, and we see that all the time in the comp world, where they'll just turn somebody down knowing that they can starve them out, and it's sickening, disgusting, but that's what they do. On the other hand, I think if insurance companies didn't have some rules, people, they would go out of business. So there's got to be some happy medium there, and I just don't know where that is. But I think the system we've got now is probably not it. It's definitely not it. So
I agree.
Be interesting to see. Okay, now JC Sports. This is an interesting question. He won his case in 5 months. That's cool. That's unusual. That's good. Obviously, something serious. He got $11,500 in back pay, and they held $6,800 to check for arrears and child support. Have you ever heard of that happening before?
Well, I know that when it goes, a claim is approved and it gets sent to the payment processing center, they do a check for any open liens, unpaid taxes, judgments,
Yep.
and certain debts are that they will withhold some of the back pay to settle some of those debts. It sounds like this something might have happened to Jonathan here.
Yeah, yeah. It actually brings up another question. I've got a client that we won his case, and there was some evidence in the past, not recently, 5, 6 years ago, there was some substance issues, drug seeking, narcotic seeking, I think was what it was, or maybe I can remember alcohol, narcotic. But basically, they've held this up, saying that he's got to get a representative payee, and he does not want a representative payee. Have you ever had to deal? I mean, is there any way around that? It's in the decision. The judge is like, Social Security needs to look at this for possible rep payee because of substance abuse. They kind of decided that's what they're going to do.
Yep.
Is there any way around it? Because he's really unhappy, and I understand. But I've called the payment center, and they're like, "Well, we're looking at it." And that's all they'll tell me at this point.
I'll be honest with you. I have not heard of any way around that. I know that they have to arrange to have a competency interview at the field office, and it depends on how that interview would go. For the most part, I mean, I've had clients that have had fairly substantial cognitive issues, enough to support a finding of disability even.
Yep.
And they'll still clear that interview to be found capable of managing their own benefits. So
Yep.
I don't know how high that standard is or threshold, but I imagine the best way is to go to that interview, hope that goes in your favor, so you can manage your own benefits.
Yep.
If it doesn't, I would think that there has to be an appeal that can be filed or explored.
My thought is, what I've suggested to him is just agree to it and get somebody that you trust as the payee, and then a year from now, make a motion or request that not be, that there's no evidence of any ongoing substance abuse, but get the money started. I mean, right now it's in limbo. He hadn't gotten paid, I hadn't gotten paid for that matter. And it's really, I'm just like, get the money started and then worry about that later on. And I realize this guy does not really, sure he's concerned about somebody taking his money, but, on the other hand, getting no money is not a good thing either. So, that was my take. Okay, so this is the person about the long-term disability. Should I continue with SSA and by the way, SSI is not disability. It's supplemental security income. SSDI is what, if you've paid into the system, what you're looking for. I don't think you need to tell Social Security you're dealing with long-term disability, but you definitely want to continue with it. There's really no reason not to. I think it benefits you to get on disability. Again, you're not going to see any more money. It's going to benefit the long-term disability company at the outset, but it gives you a backup, and I think that's really really a positive there. And she recently moved from Tennessee to Texas. Texas happens to be really slow, so it's just sitting there. That's correct, but I wouldn't give up on it. I think you don't need to. You definitely want to continue with it. Okay. Laura says, I love your videos. Thank you, Laura, and much appreciated. At what stage does SSDI ask for an RFC form? Well, they always ask for that, even with thousands of pages of medical records and imaging. Jeff, what's your take on this?
At any stage, you can submit an RFC form. Oftentimes, it's better to wait close to 1 year from the time that you stop working or from your alleged onset date. To show that your condition is at a certain level and satisfying the 12-month rule. That's part of everything. But to answer your question, RFCs from treating doctors can be provided to Social Security at any juncture of the claim. Well, certainly if you're assigned to an adjudicator.
Yeah, and by the way, she's asking, does Social Security ask for them? No, they don't necessarily ask for them. you've got to, that's something that, you and your attorney, by the way, an RFC, so you know what that means, that stands for residual functional capacity. Actually, it's not the proper term for the form, because the form is a functional capacity evaluation. Residual functional capacity is technically a legal determination that the judge makes. It stands for residual functional capacity. Residual means left over. What is the capacity you have that's left over after you factor in all of your medical issues? So when the judge is asking hypothetical questions to the vocational witness, he's presenting examples of RFC determinations of what he or she perceives to be a residual functional capacity. So if you have a doctor who's willing to fill out a form that classifies your functional capacity, that can be very compelling evidence, because what the doctor is doing is translating the medical problems you've got into very specific vocational limitations. And it helps the judge. It can be evidence that can be used to convince the judge that your RFC is, as Jeff pointed out earlier, less than sedentary, meaning that it's less than what would be required by a simple sit-down type of job. So forms from doctors can be really, really compelling. Now, is the judge required to accept the doctor's FC functional capacity? No. The judge can decide, I'm going to rely on a consultative evaluation or even a non-examining physician. But I think most judges, if the medical record is fairly comprehensive and the treating doctor has filled out a functional capacity form, most judges are going to give that some weight. Agree? Your take on that? Would you agree?
Yeah, I couldn't agree more.
Yep.
Social Security is always looking at objective evidence first to prove the existence of a medically determinable impairment. But as we know, when you file a claim, there's going to be a medical consultant opinion, the doctor that the claimant has never seen in person, simply reviewing records and offering an opinion regarding somebody's RFC. You have a consultative examination. These are really brief, really short appointments with physical doctors, psychological doctors, and oftentimes these aren't very supportive of disability. And then third, you have the opinions from treating sources. And oftentimes these can be very persuasive if there's a lengthy relationship between the provider and the client. If the provider is not just checking off boxes, but really explaining why a person has limitations, and as long as it's supported in the record, notes, imaging, or other evidence, then usually the judges will give that more weight than the other opinions in a file.
Yeah, and I would also say this, that a functional capacity form, it's you can't just have a functional capacity form without underlying medical records. So the form alone, let's say you just present a form and there's no medical records associated with it, the judge is going to ignore that. He's going to say it's not supported by anything. Second point I would tell you is, as nice as it is to have them, and I love to have FCE forms in my file, I don't think it's as necessary as maybe it once was. As Laura says, if you've got hundreds of pages of medical records that document a really severe problem, that may be more than enough. You don't necessarily have to have a FCE form, because it can be hard to get them. Doctors don't necessarily want to fill them out. They maybe want to charge you. They're really busy. So yeah, it's great to have them. Social Security will not necessarily request them, although they do sometimes in the consultative evaluations may send them one. But I just think it's just part of the picture. More so than anything else. Okay, Leanne. My AOD, or alleged onset date, is 6/1/22. It's DLI, not DIL. DLI stands for date last insured, is 3/31/24. So in other words, she's saying, I became disabled on June 1 of 2022. My insurance status runs through March 31 of 2024. I submitted more records since the date last insured. Do they consider all the records or only until the date last insured? Jeff, what's your take?
Good question, Leanne. So what the DLI represents is the date by which you have to establish a severe impairment. You've been diagnosed with a severe impairment that may result in finding a disability. But judges and adjudicators will certainly consider records after your DLI as it relates to any conditions that were diagnosed before DLI.
Yeah, but if you have something new, in other words, if your DLI is March 31 of 2024, and in June of 24 you develop, COPD, let's say, or that's not going to be particularly relevant. It's really got to be related back. And also realize that when a judge makes a finding of disability, you want them to find you have ongoing disability. So evidence after your date last insured is also going to show that your disability is ongoing. And for example, if you have a condition that is one that theoretically could resolve itself, let's say you have a surgery, they're going to want to know if you have a surgery, let's say in May of 24, and the back surgery, and let's say your back is better, well, maybe now you have a closed period. So, I think the point is, you first have to focus on the medical evidence before the date last insured, but anything afterwards, I'd still submit it. As I wouldn't, you want to submit everything, but I think they're going to, you have to meet that threshold of proving that you're disabled before your date last insured. And by the way, I find that sometimes, people reach out to me and they have a date last insured of 2018, 2020. That is difficult. I think that remote date last insured, meaning something more than a couple of years, is difficult because it's hard to get the medical records. It's hard to prove that your condition was at a disabling level 5 or 6 years ago. You're obviously younger. Would you agree? Do you find that those are more challenging cases?
Most definitely.
Yeah.
The more remote a DLI, the more difficult it is to show enough records from that time period that a person doesn't have a certain functional capacity.
Yep. All right, so your hearing's in January. Is medical evidence after the DL only considered if the claim goes to the appeals council? No, it's going to be considered by the judge. And, the appeals council, if you lose, hopefully you won't, but if you lose, the appeals council is going to look to see did the judge make an error of analysis. But again, you've got to meet that threshold of proving disability before, or that you were not able to engage in substantial gainful activity, which again, $1,550 in gross income in 2024, or some activity that looks like a job that would pay you $1,550, then, if you lose, the appeals council is going to look at, did you meet your burden of proving disability before your date last insured? If the judge was to approve you, but then say the disability came to an end, you could appeal that, and then they might look at the other. But I think that, again, get all the evidence in you possibly can, but the more that relates to your time period prior to the date last insured, the better. Okay. So you have a judge with a 65% approval. Hey, you are in great shape. We'd all love that. That's a real positive. I promise you. I would love to have all my judges with a 65% approval rate. I have 2 coming up. I have one with a judge with a 17% approval rate. I got another with a 13% approval rate.
Oh, really?
So I'm, it is what it is. And actually, the one with the 17%, I think I can win that one. I mean, I've won in front of this guy before. It's a really good case, but I'm working on my brief now. I took this case knowing who the judge was, because I just felt like this lady deserved a chance. So we'll see what happens. But I wish it wasn't that way. Okay. Eunice Sela, we thank you for well, I appreciate that very much on behalf of Jeff. We both appreciate that. Yeah, thank you. Thank you, Eunice. I appreciate that. I think I can speak for Jeff, is that, there's a lot of misinformation out there, a lot of bad information out there, quite frankly, and a lack of information. So, most attorneys in this business are trying to help people understand what's going on. We put stuff on our website. We do videos. We do these kind of things. So that's the reason. It's really about good karma. And Jeff and I have talked about this before. You put good stuff out in the world, it comes back, and that's why we do it. So
absolutely.
Okay. Okay. Fowd L says you appeal to the appeals council. You lost at the hearing. If you win, or a federal court where you get back pay since the onset. It depends. Well, first of all, most of the time, the appeals council or the district court is not going to actually approve your case. What they do is they remand it back to the judge, typically the same judge that denied you, although the second time around it'll be a different judge, but assuming that judge is still there, with instructions. Judge, you need to consider this evidence. You need to do this differently. My experience, and Jeff, you tell me if yours is different, most judges kind of get the wink, wink, do what you're supposed to do and approve this case. That's why we took it. Not all of them get that, but some judges sort of understand that the reason the case was accepted by the appeals council or district court is they think the judge made a mistake. What do you find? Do you find that judges are who get appealed and you get it back, it goes back to them, are they more open to approving, or some of them are just like, I don't care what they said, I'm going to do what I want to do?
This is a pretty relevant question for me today. I had a remand hearing earlier in the day. And I think this kind of relates back to what we were talking about a little earlier about how it's almost luck of the draw. I do think that there are really good judges that will really respect appeals council directives at the remand hearing, on those instructions, and oftentimes that does lead to a favorable decision. And I do see that there are other judges that have a different take on it. They feel as though they just find a better, favorable decision to overcome whatever mistakes were made the first time. But they're still very close-minded on the case itself. Earlier today, I had a case for a younger individual in his 30s, severe Crohn's disease. And Crohn's disease, as we know, progressive, really terrible gastrointestinal condition. And
a lot of functional limitations because it's going to prevent you from being reliable.
It does, and that's typically the way you win the case. If you can't show you meet the listing for irritable bowel syndrome, then you really do have to know that this person puts too much time from work because of how much time they're in the restroom, how long they're in the restroom for. And as I said, this was a remand. So the mistake that the judge made at this claimant's first hearing was that he did not give enough of an argument unfavorable decision. He did not have enough discussion as to why he did not follow a treating source opinion that basically stated that this person would be off task and would be absent 2 or more days per month. And since this last hearing now, this person began weekly infusions, where he would receive these IVIG infusions for hydration. It would take 5 or 6 hours a day per week. I got another medical opinion from that same treating source that's been seeing this claimant. Very consistent. I argued in my brief that it was supported in the record, been consistent. We got third-party statements, saying that this person has to take frequent breaks throughout the day, and that this person's condition has not improved. Unfortunately, I didn't have a very high approving judge, one of the more challenging judges that I've had, probably about 18%. And you could tell right from the go that he was very close-minded and was really looking not to approve this case throughout the year. Luck of the draw.
I know. I had this case a couple of years ago where there's a judge, I'm not going to say where he's from, just not a very nice person. I'll just leave it at that. Very low, 30% approval rate, which is better than 18%, but it's very low. And I appeal, whenever he turns my case down, I appeal him because he's sloppy. Right. And we got an appeal. Went to district court, comes back, and the district court. This is a fibromyalgia case, which low approval judges love to turn those down because it's such a judgment call type of thing. Yeah. And they basically said, it was kind of a weird opinion, that you've got to consider this person's subjective complaints. So he approves the case with this little, I kid you not, a 2-page footnote, essentially saying the only reason I'm approving this is because the appeals council is forcing me to do so. And I don't believe this person for a minute is to say, just on and on and on. Of course, he denied my fee agreement too, which is far for the course for this guy. But and I ended up getting paid. But long story short, but the point is, it was just I'm just like, you got to be kidding me. I mean, but even this guy who's just not a very nice person, and I don't think a particularly good judge, he still approved the case because I think I guess he's been appealed so many times. I guess he just finally got to the point where, I don't want to keep getting appealed and shot down. Maybe he's worried about his job or something. But I don't understand. I don't know why. I almost wish I could ask the guy, why, what is your point here? Why do you want to be a judge if you don't want to, you have to understand people, and again, my experience has been, most of the people who are applying for disability, this is the last thing they want to do. Yeah. I mean, they want to much rather be working. It's a lot more pleasant. They have their social life, their identity. I mean, why would you want to sit at home for 2 years waiting for disability? I mean, if you can't work, and I realize there are people who, are exaggerating, but most of the people I see are not. And I just like, why do you take this position that everybody's faking it? I just don't get that. And, why do you become a judge? Who knows? All right, Laura says, I was wondering if an inheritance is automatic. No, not for Social Security disability. For SSI, it could be a problem. But for disability, unearned income or windfall like that is not going to have any effect whatsoever. Okay. Sandy says they're getting an echo. Is anybody else hearing an echo? Because, I mean, the last time I had an echo was because my speakers were turned up too high. I've turned them down. I'll turn them down more. You shouldn't be hearing an echo, but if you are, please post it. Let me know. I just turned it down more, so hopefully you won't. Because when Jeffrey's talking, I'm hearing it on my speakers. I don't have I guess I could put a headset on. I just think it looks kind of goofy, but I'm not hearing an echo. But if you are, let me know. Okay. Susie B., I hope you're doing well. Hearing is next week. Haven't heard from my attorney on practice questions. Using your videos or any suggestions, it's a long wait. Yeah, you should probably be hearing from your attorney, if you get a hearing next week. Again, I've got obviously videos out there. There's a lot of other stuff out there. Do your own preparation. I will tell you, big picture is, I would tell you two things. Number one is there are certain questions you're going to be asked, and I've got a video about that, about just how much you can lift, how much you can carry, sitting, standing, walking, those, type of functions. You want to be able to say why you feel you're disabled, kind of in an elevator speech. But you want to be real specific, don't say not very much, not very far. And I just think you just have to, look at this through the lens of how do my medical issues prevent me from working? Now, if you're 60, the grid rules, if you've got a physical limitation, may very well apply. But I would reach out to your attorney and say, hey, we got a hearing next week. We need to talk. I think that's pretty important. Okay. All right. One of my clients, Tara, please check your email. Okay, I will do so. I will check my email, Tara. Hello, everyone. Hello, Trish. How are you doing? There's a new vocational applied person that tried ticket to work but got too little to complete it. Yeah, I don't know much about the ticket to work, but I'm thinking that anything in the Social Security world after January, was it 5th or 6th, the new rules will apply. So, yes, it will apply, I believe. Okay, Eunice says, I asked my question less about back pain. I have less than a high school education and worked at sea for 30 consecutive years as a contractor for the Army. So you clearly would be insured. Less than a high school education, in the grid rule context means it's going to be hard for them to prove you could do any kind of skilled work. If you've got severe back pain, you might very well grid out. I don't remember how old you are, Eunice. If you're over 50 or over 55, look at the grid rules. Go to gridrules.net. You can look at the grid rules. But I think that, that's the first place I would start when you're looking, is the grid rules. It's one thing that I find that the grid rules are really a great shortcut for anybody over age 50. And it's a tremendous, benefit to disability claimants because it changes the definition of disability. Do you use a lot of grid rule? See a lot of grid cases?
Oh, absolutely. what we like most about it is it takes the decision out of the judge's discretion, because
Yep.
it clearly states it directs a finding of disability as long as you can prove these elements are met.
Yep, absolutely. And I think judges like it because it is automatic. Okay, I'm getting somebody else told me about the echo. I'm going to do this. I'm going to ask Jeff to answer a question. I'm going to change microphones to the one I used last week. This is a wireless microphone, which means I don't know if there's wires all over the place that I'm going to trip on. I'm going to change back to the other one. So while I'm doing that, if you would answer this question from Robert about congenital cervical stenosis, does that qualify? And I think I know what your answer is going to be. But go ahead.
All right. Good evening, sir. I was diagnosed with congenital cervical stenosis. Does that qualify for SSDI? It certainly is a severe impairment. So we Social Security uses that 5-step analysis, and as long as we have a severely diagnosed condition, which that certainly would be, we're in the game. We're in the process here. So the next question is, does it meet a listing? One of the covered listings. It very well might. This would be a musculoskeletal condition, so we'd be looking at, I believe it's the 1.0 listings. If it doesn't meet one of the listings, then we go to step 4, which is whether or not your Robert is capable of returning to his past work. We know now that that's just the last 5 years. If the answer is no, he cannot, then step 5 is going to turn on how old Robert is and whether he can perform other work. They'll look at transferable skills if he's over 50, as well as educational considerations. So it's a very fact-dependent question whether Robert would be able to meet the standard for disability insurance. But
yeah,
certainly.
Okay. All right. So I've got my new microphone on. I will see. Can you? I hope everybody can hear me. I get this tangle of wires, which is driving me crazy, but we'll try this. Only thing I would add to that would be you don't win a disability case based on a diagnosis. So congenital obviously means it's something you've had since birth. So question 1 in my mind would be, if you've had it since birth, but you were able to work, what has changed? So obviously, as you get older, it's certainly possible that your condition could get worse or more symptomatic. But I think one question you would have to ask is, how has it gotten worse since as you were working, as you've gotten older? And the second, of course, is, as Jeffrey mentioned, severity. How severe is it? Is it something that is causing numbness going into your arms, into your hands? Is it affecting your grip? Is it affecting, your lifting capacity? Is it causing severe pain? Are you surgical? Are you on long-term pain management? Those are kind of things. So you don't win on the diagnosis. I think that the listing, Jeff mentioned the listings in musculoskeletal cases are really hard to meet. So I find, again, you may have a different opinion, but I find that when you're dealing with musculoskeletal issue, it's typically going to be a grid rule argument or a functional capacity argument, as opposed to a listing, because the listings then make it really, really hard to meet. But if you are over 55 and you can't lift because you've got this numbness in your arms or weakness in your arms, remember at age 55, you got to be able to do 20 pounds occasionally, assuming the other parts of the grid are met. So yeah, it could very well be an approval, but I think it's going to really turn on severity. And again, the question of how things have changed, because obviously if you're able to work before, you're not able to work now. Why?
Changed.
Okay. All right. So we got some echo. So I just changed my microphone. So let's see if we still have the echo. Captions aren't picking up the guest. Okay. Well, let's see if that changed at all with now this. I got this big tangle of wires, unfortunately. I don't know how to get my wire. I have what this is. This is an old microphone that is actually a pretty good one, but it was, I guess, designed for, before wireless, you had this long wire, and so it's just all over the place, which drives me crazy. But okay. What is the difference between an SSA verification benefits letter and an award letter? I guess a verification benefits basically says this is what you're getting, and an award basically says you've been approved. So I don't think that, I think that's what the difference is. Okay. All right. And Jarius is one of my clients as well. Okay. Cancer free. I filled at the end of May. Okay, this is the gentleman who's been here before with the oxygen. I just had another case with, actually, I've got another case I'm working on a brief on with a low, that's actually, I have a case with a low approval judge. The guy's on oxygen. That's why I think it's a really good case. Okay, so, okay, 4 liters of oxygen continuously, living in a very abusive place here, very toxic, no income. Okay, we're not going to talk about other attorneys, but okay, I filed at the end of May. I would think, Jeff, if somebody is on oxygen, that seems like it's listing level. I mean, I don't know how you work when you're on oxygen,
Yeah.
you know?
Yeah.
If he says he meets the listing, I agree.
I believe that meets one of the respiratory listings.
Yeah, yeah. No, it's you know, and I realize, I mean, you may meet the listing, but at the initial recon level, you know, Social Security, somebody there has to look at it and decide you meet the listing. And I will tell you that the respiratory listings, you know, they have all the different, you know, the spirometer readings you've got to meet, but it's not just one time. It's got to be multiple times within a certain period of time. So they make it complicated, and a lot of times people can't afford to get repeat tests, and that's why they turn you down. You get in front of a judge, and the judge is like, this is a bunch of garbage. Obviously, this person's on oxygen, but adjudicators, and I'm curious to hear your take on this. I think adjudicators, I mean, I know I've talked to many of them, working really hard. They're overworked. They're just understaffed. But they're typically looking for kind of listing level. They're not given a lot of discretion to make judgment calls. Is that your experience, your take? That they're
you know, there are certain listings where it is very black and white.
Yeah.
You're looking at labs, you're looking at numbers. Are we under? Are we over? Do these numbers occur within a prescribed period of time? Sometimes it can be very easy to show a judge that your client meets a listing. And other listings are very complex. It has a lot of factors. For example, like cirrhosis of the liver, they usually look at 5 or 6 different factors there. And sometimes that can be very confusing to judges they're not doctors.
right.
And there's 2 ways to win at step 3. You can prove that you meet a listing, and you can also argue that you equal a listing.
Equal listing, right.
To argue that you equal a listing, the difference there is a doctor has to give an opinion that the claimant equals the parameters of a particular listing. And sometimes, you know, that's a good strategy for disability representatives, is to ask in advance that the judge invite a medical expert to testify at a hearing, or add into a medical source statement that they're going to provide to a specialist, add the listing that we would like that doctor to consider, and put in a question, in your opinion, does your patient equal this listing?
Yep.
And if the judge feels as though that it's, you know, the case is warranted and it should be approved, and they have that extra piece of evidence that the representative is able to submit, then it could make the judge's job a lot easier in clicking that favorable button.
Yep. And by equal listing, just to kind of explore that a little bit, you know, I mentioned, for example, in the respiratory listing, let's say you have to have a spirometer test every 3 months. I don't remember if that's what it is. Let's say you have one every 4 months. You could argue that even though you're not meeting the letter of the listing,
Right.
It's the same thing. 4 months, 3 months, is it really going to make much of a difference? No. So you're really equaling the listing. And I think, but you have to have a doctor say that.
You do.
I still think, I mean, listings they just make them really, really hard to meet. So, you know, people get frustrated because they look at the listing, well, I meet this listing. They don't want you to meet the listing. And again, maybe I'm getting cynical in my old age, but, you know, Social Security, the longer the money stays in their account than yours, you know, the less the trust fund gets drained. So they're not looking to approve you early. Theoretically, they're looking to approve people with, you know, terminal cancer early, but otherwise, you know, it's going to be a battle to prove you meet a listing. And I think that if you don't want to give up, is my point. You know, that's one way to win, but you can also win on the grids. You can win on functional capacity. So, you know, you don't have to meet or equal a listing to win. All right. Emma D has $1 million question. Okay. Approximately will equal $1 million. Maybe it's 995,000. Who knows? Okay. How would one go about speaking with someone to run their situation by legal, or should we automatically run it by Social Security disability? 55-year-old. So I'm not sure if she has a second part of it. What if you've been uninsured for the past few years, become debilitated, not be able to put pins in a cup? I've sat here not going to the doctor and gotten bad. Okay, so you're raising a couple of different points here. One is, you need to find out if you're insured. So step one is go to ssa.gov/myaccount, download your My Social Security statement. It'll tell you whether you're insured now. You can look at the history to see, it's hard to really do those calculations yourself, but, you get a sense of whether you have enough credits. And that's one where if you're not sure, you could send your statement to an attorney like Jeffrey or me, and we could tell you, you're probably insured, based on this point in time. So that's step one. I think the second issue you've raised is you haven't gone to the doctor. That's a big problem because Social Security assumes if you're not going to the doctor, there's nothing wrong with you. So not going to the doctor, you're not going to win. It does help you're 55. They will send you to a consultative evaluation, but I would not rely, I don't know if you disagree, I would not rely on a consultative evaluation to win. That's my take. I just think you've got to have your own medical, you got to find out if you're insured. And if you are insured, it's going to be tough because you don't have any medical evidence going back to the time you were insured. But I don't know. That would be that would be my concerns.
Yeah, I agree. We know there's technical and medical considerations in every disability claim.
Yep.
Technical is what we want to address first,
Yep.
always when we speak to a new client. And if the person's seeking disability insurance, we have to ensure that they have an insured status and that they have something severely diagnosed within their date of last insurance. And if it's supplemental security income, then we'd have to perform an analysis to make sure that they're underneath that poverty guide limit, so that they're technically eligible. And then once you're technically eligible, now we can really review the medical. And as Jonathan said, you'd much rather be seeing your own doctors than to rely on a Social Security to send you to one of their doctors. They're very brief encounters, and they're usually not going to be very at least what I see is they're not oftentimes not supportive of disability. So by working with your own doctors, you have a better opportunity to really control that medical record and put yourself in the best position to get approved.
Yep. And by the way, if you don't qualify for SSDI, you could pursue SSI, but the problem with SSI is there's going to be offsets for any sort of assets you might have or household income. So it's a less robust program, but it's out there if you don't have the credits there. But my personal thought is, you can call Social Security. I don't know that I would necessarily rely on them they're not going to give you advice about your case. I think this is really one where, you probably want to talk to an attorney. If you're not insured, it's hard. I'm very reluctant to take SSI cases because there's always these bad surprises with offsets. Some attorneys take more of them, but you're going to have to find somebody who will take it. Jeff, do you find that non-medical evidence, statements from former coworkers, statements from friends, is that important at all? Do you find you ever use those? Does that make any difference in cases?
Yeah, absolutely. Adjudicators are obligated to evaluate all third-party statements. And typically, the more objective a statement or the relationship between the person making the statement and the claimant, the better. So former coworkers are perhaps some of the best third-party statements that we can try to collect and submit to a judge. These statements are going to be based on observations in the context of the workplace. And usually coworkers are a lot more objective than spouses, family members, and good friends. But we always encourage clients to try to get 2, 3, 795s, third-party statements. It really does help support the credibility of a claimant's allegations that they have difficulty sitting, standing, walking, all the things that Social Security is looking at. So absolutely, very much encourage clients to.
I mean, I think statements from former coworkers is really helpful because
Yes.
these are folks that don't really have any interest, there's no self-interest there, and they're talking about what they observed when you were working, and that's the primary issue in a disability case, right? So why not? All right, Sonia asks, how far back could you go? I've had 28 orthopedic surgeries. My God, Sonia, that's crazy. 28. Should I list them all? Should I stick to one listing of my current medical problems? Jeff, what's your take? That's crazy. 28.
Yeah, that is a significant surgical history there. I think that is very relevant here. To that claim for Sonia is that extensive surgical history. I think that's very compelling for the case. I definitely think they should all be listed for the claim. It's important that a judge sees that, that lengthy history of surgeries. But yes, we do want, judges are looking at what is your capacity at now? What is your capacity to do certain physical and cognitive activities now? But certainly that lengthy history of surgeries is going to be very compelling to a judge.
Yeah, I mean, generally speaking, they go back about a year and a half when you apply. So, this is one where you or your attorney might have to provide evidence of all those other surgeries.
Mhm.
And, I don't know that you necessarily need to put in, 5,000 pages of records. I think you could probably, it could be done in more of a summary format.
Yeah.
Certainly many doctors will do in a history kind of a report about that stuff, and you can make Social Security aware, I've got all the operative reports here. But at the end of the day, if you were working during all this time, then again, the question is, what has changed that you're not able to work? 28 surgeries would suggest something pretty significant. And again, any medical or any functional limitations you would have, I think it's going to be pretty reasonable to expect they would arise from a person who's had 28 orthopedic surgeries. There's obviously something really significantly wrong there. Now, again, I'm not sure if you're counting epidurals or facet injections as a surgery, but if you're talking about laminectomies, infusions, and things like that, or even radiofrequency ablation, that's maybe a little different story. I wouldn't stick. That's a very good question. Should I stick to one listing? Well, first of all, don't just limit it to listings. If you're over 50, look at the grid rules. I argue in the alternative. In other words, I would say we think this person meets listing 1.15, let's say, but in the alternative, we would respectfully argue that the combined effect of this individual's functional or orthopedic issues, in addition to depression, in addition to irritable bowel, in addition to diabetes that's out of control, and associated problems, would not be able to function reliably in a work environment. So you don't need to just go with the listings, but you want to put everything in there. Obviously, the most important things go first. I personally try to limit it to 3 or maybe 4 conditions. I'm not a big fan of putting in 17 conditions. I think that it's just going to, I don't know that that's really necessary, unless they really are all 17 cause significant problems. I try to limit it to 3 or 4 and really make my best argument. Because again, if you can't win with 28 orthopedic problems and maybe a couple other things, I don't know that listing 17 things is going to make a difference. But I would certainly list everything that is relevant, and you can make them aware that these other conditions are there. Do you find, which kind of leads me to the question of, medical record, judges are human beings, and, if they have I've had these happen before, 25,000 page records, that creates its own issues, does it not? I mean, judges aren't going to read that. So, the attorney's going to have to kind of summarize it, but what do you do if you have an unusually large record? You have VA. One guy we won the case. He had trunk. I went to his house and he had a trunk full of VA records going back 30 years. What do you do in that situation?
Yeah, certainly have had cases as well where there's just been a tremendous amount of records, and I know VA records are notorious for when we request them, they could be in the thousands of the page count, and that judges have very limited time windows to review a case, to hear a case. Part of what we do as reps is we're there to really hold that judge's hand,
Mm-hmm.
guide him through the record. Certainly, Control F is our best friend, and we want to try to make our argument succinctly at a hearing, but really point to the most relevant aspects, in the record that we can find, and do a better job at helping the judge navigate a lengthier record. I've had judges in the past, thank me for kind of really pointing to specific citations that support the RFC that I felt my client had to meet a grid rule or meet a listing. And so we're here to make the judge's job easier to approve. Uh, best and certainly a judge that sees that volume of records is already, typically is going to be approaching this case as that, okay, there's a real significant issue going on here with this particular claimant.
Yeah.
And they're more likely to approve when there's more records than a very thin record, of course. But
Yeah.
yeah, we really want to make the judge's job easier.
Yeah, yeah. Although I have had situations, I'm not suggesting this at all in Sonia's case, but there are some people out there who go to the doctor a lot, and I've seen cases where there was not a whole lot wrong, but they kept going to the doctor, and so one of the things as a rep I'm looking at is what are the findings. It's one thing to go and complain about you know, shoulder pain, let's say, but there's MRIs and, x-rays, there's nothing wrong with the shoulder, that can be problematic as well. So, one of the things that an attorney is going to do is look at the record critically. And just you don't win because you have 3,000 pages of records. You got to say something. And again, it helps if you have support from your doctor as well. And I've had cases where, people they keep going to the doctor and there's an underlying mental health case. So, that could be another element there too. So again, I'm not suggesting that with this individual here. I'm just saying that, anytime I see a record that is unusually large, I'm going to look at it from every angle. Is this person just a real medical mess? And that's the argument I'm going to make. Is there some suggestion maybe there's an underlying mental health problem? Is there some malingering? I mean, any number of different things, but you got to look at it critically because the judge will. I think as attorneys, we have to look at everything from the point of view of what would the judge think about this,
Absolutely.
and you got to look at it critically because you just don't know. You don't know. Christina is one of my regulars. Hello, Christina from California. Hope you're doing well. St. Louis, another regular. Have you ever heard of VE say one can be off task for up to 13%, 10% threshold? I think most VEs, are going to be in that 10% range. I've never had a VE say 13%. I mean, or the VE wouldn't say it, the judge would say it. I've never had a judge say 30. They're going to say 10 or 15%. And realize the judges know the VE, so they know, what the VE is going to say. So if the judge wants to deny and the VE is a 15%er, the judge is going to say off task, 10% or something like that. So, don't kid yourself. Judges know what the VEs are going to say. That, the VEs appear before these judges. They know what they're going to say. And so the judge is going to frame his question to reflect, what the VE is going to say so that it supports what the judge's conclusions are, right? So, okay. All right, Shona says, my sister, has 2,200 in both eyes. Is this a disability? It's not, and she says, is it a grid rule? No, it's not going to be a grid rule because vision issues are non-exertional. They're non-physical. So you can't use the grid rules for vision issues. But I think if your sister's vision is 2,200 in the better eye or worse, then she would meet a listing. I think that's a pretty decent shot at a listing. I've had some, I don't know, Jeff, if you've had any, where with vision cases, if they don't meet a listing, you can still argue functional capacity if there's nothing else there. Have you ever had a situation where, you have a person who has really poor vision, let's say 2150, in both eyes, but no physical limitations, nothing else, Is that enough, or do you find that you got to be at that listing level, or you have to have something other than the vision?
Yeah, that I do think there should be something other than the vision to really, for example, if somebody is over the age of 50, we know we're up against light, unskilled work. 55 and older, we're up against medium, unskilled work. A lot of times, vision impairments can eliminate past work, especially if there's computer use. But the challenging part is how do we argue that this person is limited to a light level or even a sedentary level? And I think that there could be an argument that somebody with such significant vision impairments could really limit their ability to stand and walk safely. Balance could be of concerns. So I'd really want to develop the case that way to see if I can somehow limit them physically to sedentary based on the vision impairment. In which case, I think
The
that would be
grid could have, yeah, that's a good point. That's a very good point. I hadn't really thought about that, but yeah, if you can't see well enough to walk, then you could be limited to sedentary on that basis. That's kind of a creative way to look at it, but that kind of makes sense, I guess. And of course, if you have a vision, a lot of times it's diabetes. It could be some ultimate cause of the vision problem as well. And that's, and the other question is, can the vision be corrected, or can they wear glasses or
right.
contacts or something like that? And by the way, just when you talk about vision, a question that pops up inevitably is, well, I can't get to work because I can't drive. That doesn't matter to Social Security. So it's only about if you got there somehow magically, could you perform the job?
Yeah.
Okay, so I've had a couple people talk about echoes. I hope that's better now. I mean, I've changed microphones, lowered my volume, so hopefully that's better. Okay, Jeff Brown says, I applied in 2018, 48 years old, currently 52, did not all the way to the judge. My lawyer says the only thing that held me against me is age. Went back to work, much less stringent, beginning to take its toll. My issues are primarily back problems, injections, spinal stimulator, just recently diagnosed with severe, let's see if I got the rest of it here. I'm guessing severe osteoarthritis. Okay, so I think the question Jeff is asking is, he's now 52. He's got essentially the same thing going on. It's getting a little bit worse. Yeah, being over age 50, it's going to make it a little bit easier. I think if you can make it to 55, it's going to be even better. Again, I win a lot of grid cases for people over 55. I win some, not quite as many for people 50 to 55. Again, it's just Social Security has a bias for people that are older. Big picture, work as long as you can work. If you absolutely can't do it, then yeah, you could certainly apply. But I think if you could make it to 55 and you still can't, and you really can't work, I think that's going to be stronger. I think it does make a difference that you were turned down before. Judge is going to read the prior decision. And so, yeah, that's going to hurt you a little bit. But that's kind of the way I'm seeing it. Do you see it the same way, differently?
Yeah, I would agree. I'm not sure how old he was at the time he had his hearing, if he was under or over 50.
Yeah.
If he was under 50, then the act of simply turning 50 does overcome that Chavez rule, as we know. If you when you're in that category between 50 to 54, if your past work was light or greater, then we're really trying to prove to the judge that you're limited to a sedentary level functional capacity, so we can get the claim approved per the grid rules.
Yep. I'll also look at the old decision, because if you were limited to sedentary and therefore not disabled because you don't meet the grid rules, that could be binding on a judge in a new case, right? So, right. My guess would be the judge probably limited you to light work, which again would not trigger the grid rule in a new case. And of course, a new case, they're going to look at new evidence. But certainly at 55, if you were limited to light when you were 48, now you're 55 and you got things that are worse, that's looking pretty good, right? So I think that would be a pretty good argument. Okay, so St. Louis tells me that one can go to a doctor or psychologist to get a letter asserting they can handle their finance. This is that question I posed about the representative payee. I did that. There is a form actually where you have the doctor fill out saying the person does not need a rep payee. We submitted that. but
Hmm.
nothing yet. Okay. Jeff, this is a person should be familiar to you.
Oh, indeed.
Okay. Says there's a slight echo. I don't know are you using speakers?
Um, I'm using the mic that's part of my Mac here.
Yeah, but do you have are you listening to me through speakers? Like,
Oh, I am.
okay,
I do.
turn your volume down a little bit,
Okay.
because what's happening is I'm guessing that your volume is when you're hearing what you're hearing through your speakers is being picked up by your microphone. So like I've got,
Okay.
and we're getting to our technical part of it here, but I've got a microphone, and I'm listening to speakers, and maybe I'll go to a headset next time. But I turn the volume way down so I can just barely hear you, but I'm not getting the echo there. So,
Okay. I turned my volume down, and hello, Abby. Thanks for tuning in. Abby, great story. Quickly share it is. She is a senior paralegal with my firm. She celebrated 3 years a few months back. She came to me with finishing up her bachelor's degree at ASU in technical communications. Just wonderful employee, very compassionate, intelligent, and I'm sure it was the farthest place point in her time when she first started that could she see herself advancing in this area of law. But proud to say that earlier this year she passed the exam to become a representative, and she was
great.
just cleared the red tape as of December 1st, and will be taking on hearings for the firm in February.
Awesome. Yeah, we can't, and I think we both feel this way. You have good staff people that really care, that do a good job. I mean, I've got a couple of people. Jen is on here a good number of times, and Madeline typically tunes in. And I've got several other people, but Madeline and Jen often tune in. Makes a big difference because there's only so many hours in the day. We can't talk to every single person every single day. So you want to have people that are, understand the frustration that claimants are going through, understand just the difficulty of convincing Social Security, and deal with these cases that can take 2.5 years. Makes a real difference. So obviously you've got Abby, I've got Jen, Marilyn, Iris is another person that works with me, Stephanie, Kayana. I mean, we got a bunch of people that really makes a difference. They really want to do a good job and really help the clients navigate this kind of system. So it does make a real big difference. So
it makes a huge difference.
Yep. Okay. Adam XLG, Adam extra large, I'm guessing. On step 3, I meet most criteria for cervical stenosis, X-ray for degenerative disc disease, resection of small intestine. Well, first, this is a question I get every week. People go on My Social Security account. And by the way, Social Security is asking you, if you haven't gone in recently, you've got to, they used to have you could log in with a Social Security account. Now you've got to have a MyGov, or what is it, MyGov ID or ID.gov or something. So they've changed that. So if you haven't gone in recently, go back in and change it to update your how you get in. When you go in there, people say, I'm on step 3. Does that mean it? I don't think it means a damn thing. I just think it's just a number. I mean, 85% complete or step 3. What does that mean? Anything?
To be honest, I really don't trust entirely these status updates that are given. They're very generic and vague.
Yep.
Oftentimes, they're inaccurate. I know many of our clients are constantly logging into their SSA account, checking for status updates. I mean, I'd be doing the same thing too if I were my clients, because I'd be eager to find out, but I don't really think they're very reliable.
Yep.
So I typically tell clients, take it with a grain of salt.
I totally agree. I think that step 3, step 2, it doesn't mean a darn thing. I just think it's they're just telling you that to pacify you, quite frankly.
Yeah.
But you say you meet the criteria, and again, I'm not downplaying what you're going through. Meeting a listing for musculoskeletal, it is really, really hard. I just would not assume that at all. X-rays aren't going to really be the objective test of choice. MRI is going to be a much better indicator of disc issues. X-rays are going to show broken bones, and they can show some compression, but you probably need an MRI. The small intestine resection, it's not, that doesn't disable you. The question is, does it make you have to use the restroom frequently? Are you in the restroom for 20 minutes at a time? You want to think about the effect of all these problems, not the diagnosis or the label on them. What is the effect of these things? And I think that the more these things interfere with your day-to-day or your capacity to be reliable at a job, that's what you want to really focus on.
Yeah.
Okay. St. Louis says, where is the guest based? Okay. He is based in Arizona, but I think you're from New York originally, are you not?
That is true. I'm an original New Yorker,
Okay.
but I moved to Arizona about 15 years ago, where I'm based right now.
Yep. Yeah. And if you've not been to Arizona, I've been to Phoenix and Scottsdale and what's the place with the Sedona. Been out there several times.
Red Rocks.
It's not. I wouldn't go in the middle of the summer. I would say that, but it's a really nice place. If you've not been out there, I'm in the East Coast. I'm in Atlanta, and when you go to places like Arizona or New Mexico, you just realize first of all, how big the country is, and just looking at the sky, it's just really very different. It's really, really kind of cool. So I can see why so many people go there, although not in the summertime. It's a little.
You don't want to come out here during the summers, Jonathan, and enjoy the 120s?
Yeah. Well, it's a dry heat, right? That's what they say. Yeah, I was out there one time in August for something, and it was like you open the door. It's like being in a blast furnace, But
it has wind to it. It feels like when you're outside.
Yeah. Now Sedona is a neat place. If you've not heard of it, people out there have not heard of it. Sedona is what, about an hour and a half, 2 hours from Phoenix?
About a good hour and a half,
something like that. And basically, it's sort of these red rocks, and there's supposedly all these, what is it, vibrations and vortexes and things like that. Yeah. So people, that are kind of into the new age, the crystals and so forth, they say that there's a, certain peacefulness that comes upon you in the vortexes and so forth. So it's just a beautiful, beautiful country out there. I never got into a vortex, but maybe at some point I'll get into a vortex and see if it really does what it's supposed to do. I could use a vortex probably sometimes I feel I could really use a vortex.
I could have used one earlier during my hearing with the.
Yeah, I know. What is it supposed to? I know we're getting off topic. What does a vortex do? What is it supposed to do? Just kind of reset your mind, or?
Well, I just went to Sedona a few months ago with my wife and another couple, and we actually did take they're known for Jeep tours in Sedona.
Yes, I did the pink Jeep tour. I did that.
So they had the pink Jeep, yellow Jeep, white Jeep, all sorts of color Jeep tours. And we took a Jeep tour, and our guide happened to be very spiritual and was very knowledgeable on vortexes. And he kind of gave us a whole background about the force behind it, that it's proven through science, the energy that are in the rocks. We did perform one experiment where we drove up into, I forget the specific name of the location, but we drove in, we took a little hike, and we went to a known location for a common vortex.
Mm-hmm.
And one of the things he pointed out was how all of the trees that would grow in this area, or cacti as well, that they were all twisted. They were unusually twisted. And they said that that's a sign of some, I guess, abnormal energy in that area. And we tried one experiment where we all kind of formed a circle. We had our hands outstretched, not touching each other's hands, but maybe leaving about this much room in between.
Right.
And everybody in our circle felt an energy, felt a force between our hand and the hand that we were connected to. And
that's cool.
That was the first time that I experienced it. But yeah,
that's cool. Well, my wife got these grounding sheets. You talk about grounding, and that's a big thing now, where you get these sheets and you literally plug it into the grounding plug of your, the outlet, and supposedly it helps your body heal. So she swears by it. She says she feels better. I'm not sure it's psychosomatic, but I'm sleeping on grounded sheets, so
If it
Why
helps, it
not?
helps.
Look, when you get to advanced age like me, you take anything you can get. Vortexes, grounding sheets. I don't know. Okay, let's get back to business here. Okay. Okay, so Angie talked about this. The same thing. I filled that form out, so I probably need to call on that. That's actually a good point. Now that reminds me. Okay. All right, Christina reminds everybody, please like, share, comment, and subscribe. Absolutely. All right, Luke says the echo's bad. Hopefully it's gotten better. Hopefully it's gotten better here. All right, so they're saying it's your fault, Jeff, not mine. I don't know if that's the case now, but hopefully now you've turned it down, it's a little bit better. Okay, Jeff drove a box truck delivering hospital laundry for 20 years, pushing and pulling 500 and 600-pound carts, injuring your back, working mails, delivering and picking up mail. Yeah, I mean, that's the sort of, back injury that is just cumulative over the years. They call it being a worn out worker. When you just are physically working and working and working, and you hit, you get in your 50s, that's what the grid rules were designed for, really, is people that just have worn out. So, yeah, if you're over 50, I think that's definitely something to look at with the grids. Okay, let's see what we got here. Okay, so somebody said we need to use earbuds. Okay, we will next week. I'll do earbuds. Okay. I need to empty my trash can. Oh, okay. Thanks, George. You know what that is? I will tell you. He's looking at this right back there. If I can point to it. I work at, this is my home office. And so when I print out a document that has personal information, it's got to be shredded. So that trash can is to be shredded. So I've got to take it into the office where I've got a big shredder. So that's why it looks like such a mess, because it's stuff to be shredded. I won't throw stuff away in the regular garbage that, it has to be shredded. So that's all, forms with people's social security number, birth dates, personal information. So that's to be shredded. So Bash says full trash. Yes, it's busy.
That's true, Bash.
I would say that's probably over several months. But yeah, Jeff and I were talking about this before I went on. Is he's got this nice background with a couch, and he's got a desert disability on a cushion. I got like tripod and an overfilled garbage can. So maybe I need to clean up my act. My wife would. I've got a sign in it says man cave, because my wife is not allowed in here, because she comes in and says, you got to clean this out. I'm like, I got one place in the house, I don't have to clean anything out. So my feeling is a messy office is a sign of a brilliant mind.
Productive worker.
Yeah, that's it. Okay. K-Wolf. If you're not adhering, you have to request it. It's not done automatically. You have to file within 60 days of your denial. You have to file a request for an appeals council review. Yes. Okay. All right. So I hope now that Jeff has turned his down, we don't have as much echo here, but I will take it under, what everybody's saying is that future guests I'm going to have, we're going to all do earbuds. I think that probably makes more sense. Kind of Stephanie last week, she had like a little headset, so I'll do that. I don't know if I've even got a headset. I've got, when I do my hearings, I use one of these. This is not connected to my computer, but it's just, I didn't want to do that, but I'll have to do it. So I have headsets that can connect to my computer, so I will do that. Okay. What time do I start on certain days? Okay. I typically go on every Wednesday night at 8:30 p.m. Eastern. Wednesdays, 8:30 p.m. Eastern. Every once in a while, I'll do it on a Tuesday or a Thursday. If, let's say it's a holiday, if I'm going to be out of town or something like that, we typically go for about 2 hours from 8:30 to 10:30 Eastern. But usually it's going to be Wednesday. I try to scope out Wednesday. I know there's other people out there who've got live streams. I think, what's his name? Running a blank on his name in California, in Florida. I think he does them several times a week. But I just felt Wednesday was a good night for me, just because it's middle of the week and it it just works. I that's what I chose. So typically it's going to be Wednesdays. Okay. If you have workers' comp, will DDS value workers' comp reports? Okay. Interesting question. I'll give you my answer, then I'll ask Jeff for his answer. I think that workers' comp medical reports usually are not very helpful because workers' comp, typically the doctors they send you to are not supportive of you. They are working for the insurance company. So that is evidence. That evidence needs to come in your file because it's part of your background, but don't expect it to be very supportive, is my experience. Secondly, if you have ongoing workers' comp, that's going to offset your Social Security, and you won't get any Social Security benefits as long as you're getting weekly wage benefits from comp. So Social Security will consider it, but my opinion is you need to have more than, you don't want to rely on workers' comp medical reports to win a disability case. Jeff, your take?
Well, I would say that the objective findings in a workers' comp report can be very supportive for a claim. But I would agree with you, Jonathan, that oftentimes these are doctors that the employer's insurance carrier is sending the claimant to, and may not be very supportive for disability. Just pat on the back, get back to work. But there might be some objective tests, imaging, things of that nature that could be very helpful for a case.
Yeah. Workers' comp, I mean, again, my wife does it here in Georgia, not nationally, like we do Social Security nationally, but she does workers' comp just in Georgia. And, the stories that she tells me about, insurance company doctors refusing to authorize MRIs or, just denying, people come in with severe problems and they just, well, it's going to get better, and it's real adversarial. It's just not a pleasant system. And so I'm very cynical about workers' comp, plus the offsets. And if you're getting ongoing comp, you're not going to be able to do anything with Social Security until your comp case is settled. Then there's this whole Medicare set-aside issue. It gets very complicated very quickly. So my point would be if you have an ongoing comp case, before doing anything with Social Security, you want to talk to a Social Security lawyer as well as a comp lawyer to make sure you're not going to create problems for yourself. I'll just leave it at that. Okay, T-Cash. Let's see. Okay, after waiting 2 years to get approved, my rent has gone from $50 a month to $700. My Mass Health has gone from 0 to 300 plus deductibles. Why has your rent gone so much up? Is it because you've got income now? I wonder if that's the situation. I mean, I don't know. You can mute your mic when your guest is speaking. Let me see if I can even do that. I guess I can. Okay, I will try to do that. That's a good problem here. Okay, maybe earbuds would good. They don't look as goofy. If you see me in earbuds, I got big ears. They look goofy. I'll tell you. Okay. Why do they penalize? Okay, why do they penalize someone who has no other choice other than take their disability early before retirement age? Do they? I don't think they penalize you, do they? Do you think they do?
No, I don't. I don't. I've not found that myself either.
I mean, I don't think so. I think that many people will take early retirement and then they also pursue disability. I don't think you need to. You're not getting penalized for taking early retirement. It just means that you're going for the difference between early retirement and what amounts to full retirement. So it's not as much past due benefits, but you're not being penalized for it. Okay. Headphones with cat's ears. Okay, well, I can probably arrange that. I don't know that you. Okay, now Rex says it's much better. So maybe since we echo's gone. Okay, well maybe I think that was the issue, just having to tune it down. Okay. My SSDI is only $2,000 a month after the raise in rent. Net gain is $700 a month. Kind of hard to live on that. Yeah, no, I mean, look, and this is kind of comes to the whole point of, people that are out there that are saying that folks applying for disability are trying to game the system. There's not any money in this. I mean, if you're gonna game a system, Social Security is not the one to game. I mean, there's not enough money in it. I mean, $2,000 a month, that's $24,000 a year. Not a lot of money. And I think most people would much rather be working, not only because it's more money, but because it's more fulfilling. So, when I hear people talk about, oh, everybody's faking it, that's a bunch of crap. Nobody's faking it. It's not true. Nobody. Most people are not faking it. This is not. I mean, why would you wait two years to get $2,000 a month? It just makes no sense. Makes no sense. Okay, Vincent, one of my clients, late to your party. Who is my guest? This is Jeffrey Herman. Vince, Jeff is a disability attorney in the Phoenix, Arizona area. He's got a law firm called Desert Disability. We've been friends and colleagues for several years now. Okay. All right, interesting question from George. What do you think the Trump administration will do for SSDI going forward? This is an interesting question.
Hot
Jeff, what do you
topic.
think?
Well, so from my understanding, there has been talks and speculations of continued budget cuts at Social Security under the new administration. So what I think we could see happening, if that were to be true, is even longer wait periods for claims to be assigned, for claims to be evaluated at the field office. As it is right now, Social Security is one of the more underfunded government agencies. And I think I recall hearing not too long ago that the ex-commissioner O'Malley recently had an audience at Congress to try to get some more much-needed funds for Social Security. If speculation turns out to be true and there is no further money forthcoming, or if there are further cuts to Social Security, I think it's going to result in just lengthier wait times than we have right now, which is truly a shame.
Yeah. Well, there's a new commissioner been nominated, and I just put in the comments section an article from Charles Hall's blog about it. His name is Frank Bisignano. I don't know how he pronounces it. And Mr. Bisignano is, I think, worked in finance. I don't know anything really at all about him. I mean, basically what Charles is saying is that, if he thinks he's going to make any changes without money, nothing's going to happen. Now, Charles, very opinionated about things and certainly not a fan of Mr. Trump. And the last Trump administration, he had a commissioner, what was that fellow's name?
Was it Saul?
Saul, right. Andrew Saul, who didn't even live in Maryland. He lived in New York and, was not very popular. He was very much about not allowing for telework and so forth. We'll see. I mean, I think that, Nosker essentially has come out and said, we'll work with whoever the commissioner is. I think O'Malley was very claimant friendly and was trying to help claimants. I don't know that Mr. Bisignano is going to be like that. I think the point Jeff is making is that, Congress controls the purse strings. And the reason why we have such a problem here is there's not enough money. And they don't want to allocate money to it. I mean, I've said this for years. Social Security disability claimants are not a lobby. AARP it's not a priority for them. So, they just don't have enough money. It's going to be longer waits because they have to process these claims. They don't, and again, the Charles Hall argument is that Social Security is a teetering on the brink of disaster. I'm not sure if I'm quite there yet, but he makes a pretty compelling argument. There is just a lot of, it's a mess. We're dealing with clients and we tell people assumed a 2-year wait. That's ridiculous if you think about it, that you have to wait 2 years to get a decision about your disability, because during that 2 years, you're probably not going to have insurance. You can't go to the doctor. Then you get to a hearing. Well, we're going to turn you out because you didn't go to the doctor. Well, how are you going to go to the doctor if you have no insurance? Right. So it's a problem. And I think that, this is another reason why I tell everybody I talk to, if you can hang on at work, hang on at work. Don't assume this is going to, do it for you. I mean, obviously we take cases because people really can't work, but it's going to be a challenge. And I think that challenge is probably going to get more challenging, if you can say it that way, just because of it's Congress. It's not, I'm not going to blame any commissioner. I mean, the commissioner only can do what he can do. I mean, O'Malley, I think, was very pro-claimant, but he couldn't do very much. He did he did one thing, I think, which was really helpful, getting the look back from 15 years to 5 years. But, anybody's guess what Mr. Bisignano is going to do. So we'll see. All right, Hank says, I'm on SSDI turning 65, do I have to reapply? No, you have to reapply. I think they're going to, once you get full retirement age, they'll convert you over, right? So I think that's what happens at that point. Okay. If you receive workers' comp settlement, will that affect your SSDI? Yes, it will, unless you have, it will, but what you want to look for in your comp settlement is language that's called a Hartman clause in your workers' comp settlement that basically says this lump sum will be treated not as a lump sum, it'll be treated as if it was being paid out of your expected lifespan. So if you have 30 years expected lifespan, you take your $50,000 and divide it by 30 years, it comes out to however many dollars per month. That is what will reduce your SSDI payment. If you don't have that in there, then you offset your SSDI until you hit that amount of the comp settlement. So you want to make sure that your comp lawyer puts it in there. Do you have that same sort of thing in Arizona, Hartman, or something like that?
Yeah, I believe so. I believe that's nationwide.
Yep. Okay. So yeah. So to clarify, if you're getting ongoing comp benefits, that is going to be a problem in terms of getting Social Security, because as long as you're getting comp benefits, you're not going to get any Social Security benefits. Means there's no past due benefits. So you go to an attorney like Jeff or me and you say, well, I want to hire you. I'm like, the problem is I only get paid if I win on past due benefits. There's no past due benefits because you're getting comp. I can't take your case on a contingency. That's point one. Second thing is, if you have a settlement that was, let's say, settled 6 months ago and you want to apply, you got to make sure you have that Hartman language in there. The other thing you want to look for is sometimes these settlements say you agree that you are not going to file for Social Security for 30 months or 39 months or something like that. So you want to really be careful about that as well. Okay. What do you put in a brief? Jeff, what do you put in a brief in a Social Security case?
That's a good question. Well, a brief, we want to be concise. So we don't want to send pages upon pages to a judge. I typically keep a brief to anywhere between 3 to 5 pages. I'll go through a background of the claimant, provide a section about their work history, and then really what I'm doing is I'm going through that 5-step sequential analysis. I'm explaining why a claimant passes step 1, which is that they're not engaged in substantial gainful activity, that they pass step 2, that they have a severe impairment, which I'll identify. I'll have a discussion about step 3. Does a claimant meet a listing or equal a listing? Usually at the hearing level, that's more rare to make listing level arguments. Typically, claims will be approved at the field office level if we can show that the listing is met. Majority of the brief is going to be focused on step 4 and step 5. Step 4 is, can the claimant return to their past relevant work? And step 5 is, can the claimant perform other work in the national economy? And that's where the bulk of a brief will lie. We're going to go through the medical records. We're going to point out, the objective evidence in the records to substantiate the severe impairments. We're going to pull from it the best evidence that we have from doctors' opinions, consultative exams. But essentially, we're presenting to a judge a theory for disability or multiple theories for disability to make that judge's job much easier to prove the case.
I've been muting myself, so I'm muted. Yeah, I absolutely agree. I think the point of a brief is to kind of, I think it does a couple of things. One is you're setting out the theory of your case. Is it a grid rule argument? Is it a listing? Is it functional capacity? I think you're also giving the judge kind of a story. I'm a big believer in narratives. I think that, human beings are kind of hardwired to find a narrative. And I think if you can paint a picture of your client as a hardworking person who worked through a lot of difficulties physically, kept working, finally got to the point where he simply could not do it anymore. And here's what the medical evidence says, and here's what his condition is. If there's lack of medical evidence because of financial reasons, you want to put that in there. It's just you're telling this client's story, and you're kind of, humanizing that person. This is a real individual who is reluctant. They don't want to be here, but they have no other choice. I think you're also, as the attorney, we're sending a message to the judge. We're prepared. We understand the concepts here. We know what's going on. There are judges, I will tell you, and I've been in front of some who, if they've never seen you before, and now with things being remote, it's more likely that's going to happen. They want to test the lawyer. Do you know what you're talking about? And there's some judges who, if they sense weakness, they sense you don't know what you're doing, they'll pounce, and they will, it's a power thing, I think, but they will try to, make you look bad, make you look like an idiot in front of your client. You do a brief where you spell out the theory of your case. You're clearly talking about past relevant work, and the 5-year rule, and all you know what you're doing. You're sending a message to the judge. I know what I'm doing. So they don't try the BS with you. I think they respect the fact that you're taking the time to do it and you're making an argument. And I've had judges say, I'm sure, Jeff, you have as well, I really appreciate your taking the time to lay this out and set this out for me, and it's very clear. And so, so I think that's what a brief does. I think it just really spells out the argument, but I think you're painting a picture, you're creating a narrative, but you're also sending a message that I know what I'm doing. Mm-hmm. And I think that's all to the benefit of your client.
Oh, well said.
Okay. All right. Lulu's after party. Will they call you? If you're approved, they'll just send you a letter. I use a little program called Chronicle. There's a bunch of different ones out there, and there's one called Assure a lot of people use as well. But I'll see if I get an approval, I'll see it in real time. And you can also check in. All the cases we have, we can log into something called the Electronic Records Express, and you can look at status reports and you can see. So I'll know before the letter comes out, but it's done in writing, not by phone call. I think Social Security is reluctant to make phone calls because there's so much fraud. In fact, if you call Social Security, before you can talk to anybody, you have to listen to this long voicemail message or automated attendant message. And one of the things it always talks about is, somebody calls you and they're saying from Social Security, don't give them information because it's probably fraud. And in fact, I get calls from adjudicators and I'll ask them, okay, tell me what you know before I tell you anything about my client, because, who knows who these people are. So,
yeah, absolutely.
Okay. My case was remanded. Why are they requesting an online versus, you mean a video? I think that's what you mean.
I assume he would mean Microsoft meetings.
Yeah. Yeah. So it's just, that's something also that's new. Is it used to be hearings were all done in person. Then after COVID, everything went virtual, and then they started doing live hearings again. And NOSCR had a form that I still submit with all my, notice of appointment and hearing request asking for a phone or video hearing. Now Social Security's got its own form. So it's just another form we got to fill out. But it's a, now that the standard, the default is phone or video. I've done both. I find the phone hearings I prefer those because there's less to go wrong technically. Videos are fine, but what do you think? Do you typically prefer phone or video, or do you have a preference?
That's a good question. Phone or video, I mean, pre-COVID, it was commonplace to have to go to the hearing office and have it conducted in person. For convenience purposes, for all parties, it's always nice to have the ability to conduct hearings remotely. So I'm still thankful that we're able to do that.
Yep.
Phones, telephone hearings tend to be the most common hearings that I have. I'd say, I'm doing about 6-8 hearings a month. 85-90% of my hearings are conducted by telephone. As we know, cases are really rooted in the medical. So I don't know from a strategic standpoint if it really makes too much of a difference between phone versus video.
Yep.
If my client has something physical that I would want the judge to see, I would rather insist on an in-person hearing than have it over video.
Yep.
Because the video is very limited and,
right,
what you can see. And I'm sure, Jonathan, when we're doing phone hearings, we're able to mute the phone, we're looking at the record, we're
right,
looking at this or that. We're not on video in front of the judge, but when it's over video, now we know the judge is able to see us. So that does limit some of our abilities during the times of a hearing when we're not active. So
Yeah.
other than
Yeah,
that,
I don't think it makes really much of a difference. I mean, I just like the phone, like I said, because I think it's less to go wrong in terms of the technical part of it. And I think a lot of people, when they do a video hearing, if they don't have a really strong internet connection, or if they're using a tablet or a phone, you don't want to be kind of moving around and so forth. So
right.
just for that. So, okay, so we got about 10 more minutes here. So we'll kind of zoom through some of these. Um, 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 Our Fergman, and we've communicated a little bit, how do you pick which doctor to put on your SSD forms? Use the VA and see a different doctor every time? Do you go to the doctor? Um, I don't know that you just say you could just choose really any doctor for the form. Now, the VA is supposed to cooperate. So, what I might do is send or give you the form and just take it to the doctor, and whoever you happen to see, ask that person to fill it out. So I don't know that you necessarily have to put the doctor's name on the form, is what I would say. And I know we you and I have spoken on the phone. We didn't talk about this particular issue, but that's what I would say is I would just give you the form. And if we get to that point, we'll give you the form and you just take it to the doctor and whoever happens to be. And yeah, it's a little less it's not as preferable as having the same doctor every time, but they do obviously see different people. But there are some specialists at the VA that will be able to help with you. But at the end of the day, if you get any of the doctors at the VA to fill out a form, that's a net positive, I think. Okay, Jen. So Jeff's paralegal was here before, so I said some nice things about you. So here's Jen. That's Jen's with paralegal
Jen.
works with me. So okay. All right. Vincent says hello, Jen. Okay, we fixed the echo. Good. Okay, that's cool.
Oh, good.
Vince says sounds like using Mr. Microphone. That's not very nice, Vince. Okay. So my clients are smartasses. That's why I love them, because they, All right. Thank you both for taking the time. If you're not hearing, okay, I think we already asked that. It does not, it's automatic. Okay, ID, that's right. ID.me, there's gov.
That's
Something, there's two of them. It's, something gov and ID.me is the other one. Okay, we talked about step 4. That doesn't really mean anything. All right, Tara's asking Jen. I think Tara told me to check my email, but Jen, I guess you sent it to both of us here. Okay, I've got a couple more questions here. Okay, I got the cervical MRI. Okay, that's helpful because that will, that's a very helpful test to have. Okay. Here's an interesting question. The best approach is to call SSA for reps for status updates. If you call Social Security, you're not going to get very far. And honestly, things happen really slowly in Social Security cases. I don't know, when you say there's an update, I mean, really, there's not a lot that happens. I mean, what I look for when I'm looking at the underlying activity in a file is Social Security requesting and updating medical records. That's really what I'm looking for. If I see a file that I've been touched in 3 or 4 months, that's a red flag. But otherwise, they're not going to update you. They're just going to make a decision. And, what you really want to look for is, are they working on it, right? So that's my take on that. Okay, so now we got another smartass here. The echo is lawyer double talk. What do I do to deserve my client? These are folks that are supposed to be my clients. They're supposed to be nice to me.
Hey, they got a good sense of humor.
Yeah, tell me about it. Okay. My lawyer know with the phrase, please review into grid rule. Okay, that's because that's what I suggested that you do. I mean, you can't, I always tell people, if you've got a lawyer, stick with your lawyer. Social Security makes it really hard to change because the other lawyer would have to withdraw and waive fees, and otherwise you got to file fee petitions. So I'm never going to tell somebody to change lawyers. I think you just want to, but talk to your lawyer. If your lawyer doesn't want to, assert a grid rule, why? I mean, it makes no sense to me. I mean, if you're over 50 or over 55 in this case, why would you not assert a grid rule? I would just ask why. I mean, it makes no sense to me. Who knows? I don't know. All right, a pricey. So, but I would say before you start terminating an attorney, really to have a talk with your lawyer and just say, look, I'm really confused about this. This upsets me. Can you spend 5-10 minutes with me and just walk me through why you're opposed to referencing the grid rule in a denial or an appeal?
Yeah,
Okay,
I agree.
vocational law. We just were talking about this pricey joy. I'm just going to kind of recap, and this is all being recorded, but big picture is that up until this point, Social Security has been using something called the DOT, or Dictionary of Occupational Titles, which was last updated in 1991. Now they've broadened the scope of what judges can talk about. The vocational witnesses can talk about their own experience, other sources. And Jeff made a little kind of a brief summary of all this. His take is, and I would agree, that the vocational witnesses will be more empowered to find other reasons to come up with different jobs. It's going to be harder to challenge those. With the DOT, you could challenge them pretty easily because some of those jobs are obsolete. Now they're looking at a lot of other different jobs. And there, I will tell you that there's a lot of different statistical things out there that get really granular about figuring out the number of jobs that exist. And some attorneys really get into that granular stuff. I'm focused more on, do I have a strong case? But I can see a reason to get more granular. I'll just leave it at that. But if you want to know more about this, look at the beginning, first part of this, the replay. Okay. Let's see. Christina says, oh yes, leave a 5-star review, please. Absolutely. Okay. Okay, let's see here. Okay, so we're gonna end up with a couple more questions. Just got a note about cost of living increase in SSDI, but Medicare premiums increase. You should see a net positive there.
Yeah.
Okay, you're still great. Well, good. I'm glad you're grateful. Okay, even though you didn't tune in early, but you're still grateful. Okay, that's fine. All right. Jeff, why does Social Security want school records on top of medical records for child SSI claim? Good question.
Yeah, that is a good question.
Yeah.
Well, school records could be very helpful for Social Security to assess difficulties, with academics, difficulties with either difficulties with other students, disciplinary issues, not completing a certain grade in school. Basically, school records are a very objective way to show that there is some intellectual limitations for the child, and that's a common criteria for a lot of for child disability claims is showing how the underlying medical condition impacts the child's reasoning, ability to learn and understand information, to concentrate, and school records can really, help show the significant difficulties a child might be having in a school environment.
Yeah, and I think also school records, if you're older and you've got, let's say, a chronic mental health condition, this could show this has been going on for many, many years. And again, the argument you got to make is, even though I had it as a child and I was able to work through it for a period of time, this is not new. This anxiety issue, this bipolar, the schizophrenia, whatever it may be, this is ongoing. And of course, medicines sometimes lose their effectiveness over time. So, it can be very, very relevant to an adult claim even, not just for a child claim. Obviously for a child claim, that's going to be, there's not going to be work records, but this is going to show this person has significant issues.
Absolutely.
There.
Sometimes school records can be easier to attain than medical records from way back.
Yep. Okay. All right. So Pricey Joyce says it's Emily from Texas. Hello, Emily. How are you doing? Okay. So let's see if we got time for one more question. I definitely see people are making fun of us, which is not nice, but I'm just joking. They can make fun of us all they want. They're agreeing that nobody's going to file for disability just because it takes such a long time. All right, this is an interesting question. I have not. Have you? If I have, I don't know much about it. What do you know about the ticket to work? Do you know? I mean, I put you on the spot. Do you have any information about ticket to work?
Well, I'll admit that my knowledge basis on the Ticket to Work program is not extremely strong. I'm familiar with the purpose of the program.
Yep.
It's designed to help people that are on disability find work. So I know they have vocational and occupational aspects to it to really help people that are receiving disability get paired with an occupation that might provide them with the types of accommodations that they would need to be able to work. I think from a bigger picture perspective, by having the Ticket to Work program and offering resources to disabled individuals, it really does help them get back into the workforce and perhaps earn over that dollar amount where we know if they earn, I think it's 9 or 10 months in a 60-month period, then they'll be removed off of disability. So there might be a bigger scheme behind the Ticket to Work program to limit the amount of benefits that a disabled individual does receive. But as Jonathan and I have often talked about, it's a lot more lucrative and rewarding to work than to simply collect the benefits. So I really, give clients that want to work. I really, applaud that work ethic, and I think there's a lot more benefits than not to the Ticket to Work program.
Yeah, and I think that, big picture Social Security is looking for ways to help people get back into the workforce.
Yeah.
And so without, discouraging them from trying, because, obviously if the word got out that trying to work or doing a Ticket to Work or doing, trial work period was going to cause you to lose your benefits, nobody would do it. So they are trying to encourage people. At the same time, they're also on the alert for people who have regained capacity. So it's kind of a balancing act. But the Ticket to Work is one, and I admit I don't know much about it, but it's basically one way for people to, to try to get back to work, as is the trial work period. So, okay, we are now at about 2 hours, so we're going to wrap it up for today. I want to again thank Jeff, and Jeff, just hang on for a second after we end. But thank you very much for taking the time to join me and answer questions and to give us your insight about the new vocational rules. We will definitely do it again at some point in the very near future. And just so people know how to reach you, if they want to reach you, how would they do that? Tell them about your website and about how to reach you if you have a second to do that.
And thank you for having me, Jonathan.
Yeah.
I just have to share one quick story about how I met Jonathan in the first place. I've been practicing this area of law now for a little over 6 years. My father practiced this area of law for over 30 years before he retired. And my father really, was an instrumental role model for me to get into this line of law. He encouraged me. He sent me a lot of resources to help educate me on Social Security disability claims, how they're handled, how you win them. But I found that there was a lot of information that he didn't share with me as I was embarking on this new career. I was thirsty for more information. I remember I was just kind of surfing through YouTube, looking for some resources, and I stumbled upon your channel, Jonathan, and I was overwhelmed by the number of videos that you had in there, a large library. But I found that, comparing your videos to some of the other videos I saw on YouTube, you speak very naturally. It's not pre-prepared. There's no scripts. Other videos, a little bit more dry. You could tell an attorney's reading. So it wasn't very engaging. All your videos were between 5 to 7 minutes. So, great for the short attention span that all of us have these days with just so much out there. And it was really instrumental for me to help accelerate my learning curve. I learned a lot from your channel. And so decided to reach out to you and just thank you for all that knowledge that you share. And that's how we started a friendship.
Yeah, absolutely. I appreciate that. Yeah, look, and again, I know that, everybody I've had on this, that yourself and, certainly, like I said, we all want to share what we know. And, this is a nice practice area in that most of the attorneys who are in this area are willing to share what they know, and they're not, there's plenty of good cases out there. And at the end of the day, look, I mean, we make a living out of it. You're not going to get rich doing Social Security disability, but you make a nice living. But at the end of the day, we're trying to help people who really need the guidance, because Social Security is become such a complicated bureaucracy, and just all the acronyms is very hard to follow. So yeah, I mean, you want to share what you know. And so, I try to share with other attorneys, with the public. And again, having folks like you on to share what you know is sort of helps that. So I appreciate the kind words, and I'm glad that we, got to know each other that way. So
Absolutely.
very cool.
And
Okay.
if anyone would like to reach me, they can visit my firm's website is www.desertdisability.com. My email, Jeffrey, Jeffrey, @desertdisability.com. If anyone has any questions, we also do claim assessments as well. Please feel free to reach out.
Cool. Okay. Very good. And to reach me, I think everybody can see it's in the bottom there, but ssdanswers.com is my website. And, again, happy to answer questions and obviously take case evaluations as well. So, all right, we're going to end the stream. Again, Jeff, hang on for a sec, but appreciate everybody's being here, and we'll see you again next week. Thanks a lot.
Thank you.